Sir, who are you? Sir, who are you?
Just a friend of Matthew's. I just literally doing some of these. I've been helping him out through this. I can leave if you like. But listen to it. My name's John. Graham John.
Have you written emails to Ms. Rieder?
That's not.
Okay, all right. You can remain. All right. So, you write back and forth in emails, is that correct?
Yes, ma'am.
How many emails have you written back and forth?
This whole binder right here, I would say over about 100 emails.
Between you and Ms. Rieder?
Yes. And not only that, Your Honor, the day that the district attorney read off that plea, I was kind of confused because they had sent me a different plea offer. That wasn't even a plea bargain that was explained to me properly, because for a long time I was given a different plea offer, and not only that, the district attorney sent her the same exact plea, but when she came in here, she explained another plea offer to you. And moments after that, after court that day, she then wrote me an email explaining to me how she can get certain charges to go away and stuff like that. And it's like, she know that I don't want to take a plea offer, so why?
All right. So let me tell you where we are right now. This is the lawyer you will have, or you can represent yourself. Those are your two options. You have a right to a court-appointed lawyer, but you don't have the right to any court-appointed lawyer. You have the right to a court-appointed lawyer. And in this circumstance, we've provided a number of opportunities for you to have a court-appointed lawyer. It is not unusual for a lawyer and their client to see things differently. That's not unusual. It's not uncommon. It's also not unusual or uncommon that a lawyer will say, this is a good argument, this is a bad argument. You can make progress with arguing this. You are never going to make progress on arguing this. Or you don't have a very strong case, which is potentially not in your best interest to take it to trial, or you have a good case. And I know it's an imposition to go to trial, but you should. I don't know what has been said. Here's the circumstance. If you wish to represent yourself, that is a serious decision. I had you think about that the last time I talked to you, and ask that you think hard about that decision. You're not legally trained. If you try and represent yourself, people who do that tend to make mistakes, which are not in their best interest. An attorney has experience and knows the law and knows how to proceed in a trial. You can make trial strategies like I talked about. This is a good argument, this is a bad argument. But sometimes those trial strategies, again, could be a mistake. So the question is, you have your right to remain silent. If you choose to testify at trial, you're giving up that right to remain silent. You do not have to testify at trial. The jury cannot use that against you. You've been told what the possible consequences are if you were convicted. Those are big consequences. There will be issues like these motions or other issues at trial that you are not schooled to understand and argue on your own. Ms. Rieder has told me, and I believe that should be a representation of an officer of the court, she is ready to go to trial on the date that I set. She is ready for motions on the date I set. It is your decision whether or not you want to have Ms. Rieder dismissed as your lawyer. That said, you're not going to have a new court-appointed attorney. So you're choosing between representing yourself and being represented by Ms. Rieder, because it's really clear from the cases of the Supreme Court, Court of Appeals, you have a right to a lawyer, you have a right to a court-appointed lawyer, but once you gin through a number of lawyers, they say, we've met our burden to provide you a court-appointed lawyer. And that's where we are. I need a decision. Do you want to work with Ms. Rieder, even though at times you may not agree? Even though at times you may not agree on a decision for you to take the stand, a decision to put on evidence, she may tell you it's a bad idea. You may not agree. I can't promise you you're going to agree. But acting in your best interest is her job. Whether you like it or not, she will never refuse to put on evidence that you insist that you wish to put on. Unless the person's lying, and then we get into other issues. Because she can't knowingly put a person on the stand who's going to lie. But other than that, so, I understand your position. However, it is a really, really, really bad decision to give up the services of a good lawyer to represent yourself, even if you don't see eye to eye. So, there we are. Mr. Johnson, what do you want to do?
I'll keep her and work with her.
Thank you.
You're right. I can't get up and represent myself in front of. I just don't have the experience, like you said, flat out.
All right, Ms. Rieder, you are on the case for the remainder of the case, whatever the remainder of the case shall be. I assume that you will continue to give your advice, which he may or may not like, and he may follow it or not. And I assume that other than putting on a witness to lie, you will listen to your client's instructions, whether they're in his best interest or not. Ms. Rieder.
And thank you, Your Honor. And based on Mr. Johnson's statements under oath to the court today, I assume that he now intends to respond to my emails and will provide me with information about the witnesses or evidence that he has so that I can prepare his defense.
Okay, those are reasonable requests.
Yes, it is.
Okay, and if you don't give her what she needs to know, she can't represent you well. Okay? Now, it may be that you have some internal reason that you don't want to give that up. just understand that ties her hands as to representing you well. If you were someplace for some, let's take a hypothetical. You were someplace for some bad reason, okay? Whatever the bad reason may be, committing a theft. But somebody tells a police officer and you get charged with committing an assault on the other side of town. Would be in your best interest to tell her you committed the theft. And that's where I was at the time. I wasn't committing this over here. Now, she doesn't have to tell anybody you were committing the theft, or she may. Do you understand that?
Yes, ma'am.
Okay. You have to be absolutely honest and straightforward with her so she can represent you. She's not going to tell anybody what you tell her unless it's in your best interest or it helps your case. That's her job. Your job is to trust her because that's her job to help you. Okay, Mr. Tingley, we're going to listen to this doctor when the doctor comes, correct?
He's here.
Oh, perfect.
He's in the hall.
All right, let's do that.
Dr. Hardison.
All right, thank you. Mr. Johnson, if you'd stand back up. I'm sorry I have to ask this, okay? And I apologize for the fact that I have to ask this. Have you had any drugs or alcohol today?
Not me, no.
Okay, not you. Are you sure of that?
Yes, ma'am.
And under penalty of perjury, do you tell me that you have not consumed drugs or alcohol today?
Yes, ma'am.
All right. And do you fully understand what has happened today?
As far as what?
As far as you deciding you're going to go ahead and proceed with Ms. Rieder?
Oh, yes, ma'am.
Okay. Anyone made threats or promises?
No.
All right. Thank you. Go ahead and have a seat. The question became who of a couple of people had engaged in inappropriate behavior before coming to court. I wanted to make sure that Mr. Johnson was not that person.
Very narrow.
Okay, and so we've accomplished that. I think that's consistent with what the officers have told me, that of a couple of people, it was not Mr. Johnson that was the problem. Was not the person who had engaged in behavior that they shouldn't have engaged in before they came to court. So it's consistent with what the deputy impressions were. I believe Mr. Johnson for the record, and I believe that it's knowingly and voluntarily that he remained